Good evening, ladies and gentlemen. Well, to state the obvious, price is one of the primary ways in which sellers of products compete. Catherine Payne, former Chief Marketing Officer of News Group International, said that the moment you make a mistake in pricing, you're eating into your reputation or your profits. This evening, I'm going to look at pricing in the context of EU and UK competition law, specifically price fixing and resale price maintenance, and how those practices could eat into both your reputation and your profits. Whilst most businesses know that price fixing is against the law, it actually occurs on a very regular basis, particularly in the form of suppliers imposing minimum resale prices on distributors and retailers. And this is partly due to a lack of understanding as to the range of pricing practices which do fall on the wrong side of the law, but also, I think, due to there being inadequate training within organisations and inadequate supervision of account managers and those on the front line of managing sales. The general rule is that companies which do not have a dominant position in the market, with which we're concerned this evening, can charge the customers what they like. They can quote on an ad hoc basis, they can sell by reference to list prices, and they may refuse to supply customers who won't pay their prices. But the two golden rules of pricing are as follows. First of all, in setting their prices, parties mustn't collude, cooperate, exchange sensitive information with their competitors. Prices must be set independently. The second golden rule is that companies must not impose minimum resale prices on parties lower down in the supply chain, distributors, retailers. In the UK, the Competition and Markets Authority, the CMA, is the regulatory authority with investigatory and enforcement powers in respect of competition law issues, including pricing issues. And it will apply both UK law and where the particular practice in question has an effect, either actual or potential, on trade between member states, it must also apply EU competition law. And the objective of competition law is quite simple, is to ensure that competition within the market remains undistorted and that consumers get access to the best deals and the best prices. And the rules on pricing, I know this is the agent law seminar, but the rules on pricing that we're going to talk about this evening, they don't affect agents in their genuine agents in their sale of products on behalf of the principal, because agents are seen as kind of part of the supplier for the purposes of selling products to other parties, but they do apply to suppliers, distributors and retailers. So what are the penalties for breaching competition law? Well, they can be severe. Fines can be as much as 10% of worldwide turnover of the goods or services in the previous year. There are also risks for individuals, risks for directors specifically. Directors can be disqualified from running a company for up to 15 years if they're involved in breaches of competition law, and often these relate to pricing. So if the director's company commits a breach of competition law, fixes prices with a competitor, for example, and if the court finds that the conduct of the director contributed to that breach of competition law such that that director is unfit to be a director of a company, then the director can be disqualified. So what makes you unfit in those circumstances? Well, it's actually a variety of things. If the director contributed to the breach of competition law, and that's even if the director didn't know that it was a breach of competition law, what was happening. Also, if the director had reasonable grounds to suspect that the conduct was a breach of competition law, but took no steps to prevent it. And finally, if the director did not know but should have known that what was happening, what was being done by the company, was a breach of competition law. Finally, in terms of risks for individuals, in the most serious cases, the cartel offences as they're called, individuals can go to prison for up to 5 years for being involved in such practices. So cartel offences are agreements between competitors operating at the same level of the supply and production chain, and often include prices, agreements relating to price fixing. So an individual who agrees with other individuals to make or implement a price fixing agreement between competitors can be prosecuted, and prosecutions have been brought against directors in the past. So what is prohibited? Well, the answer is a whole range of different pricing practices. First of all, we're going to talk about horizontal agreements, which is agreements between competitors, those at the same level of the supply chain, and secondly, what's called vertical agreements, so agreements between parties at different levels of the supply chain, so suppliers, distributors, retailers. So first of all, horizontal agreements, agreements between competitors. Agreeing with competitors to fix prices is prohibited, but it won't just include fixing the price itself, but also fixing components of the price, setting a minimum price, setting a percentage by which prices must rise or cannot rise beyond, and setting a range of prices outside of which prices aren't allowed to move. And there are many methods by which price fixing is achieved. So recently the CMA conducted an investigation into 2 sellers on Amazon Marketplace. And what they had done was they had configured automated repricing software, which is often used by sellers on Amazon Marketplace to keep prices competitive. And what they've done is configured it to keep prices high. And that was a recent investigation by the CMA. Amazon wasn't involved in that investigation. It was just the 2 sellers themselves. It's also worth bearing in mind that even the exchange of information between competitors on price information or other competitively sensitive information can lead to breaches of competition law. So it's important that when discussing with competitors any aspects of trade issues, and these often, these sorts of conversations often occur at trade association meetings, committee meetings. It's important that pricing and other competitively sensitive information isn't shared, because otherwise you could be stepping across the line of what is within the law and what is not. Secondly, then moving on to vertical agreements. Well, price fixing between parties at different levels of supply chain can often arise. So, for example, suppliers imposing minimum prices on distributors and distributors on retailers, and often you'll get a trickle-down effect where suppliers will put pressure on distributors to impose minimum prices on retailers. Fixing, this is what's known as minimum resale price maintenance, and this can occur either directly or indirectly. Directly, it does what it says on the tin. It's, the supplier fixes a specific price, minimum resale price, but more common in our experience is the indirect form of resale price maintenance. So that can be, for example, where the supplier fixes a maximum level of discount for the product, the sale of the products, and making the reimbursement of promotional costs subject to abiding by a particular price, linking the resale price to resale prices of other parties, of competitors. One that we've seen recently is minimum internet advertised price policies. So there was a case of an online seller recently who, in their online guidance, imposed minimum prices for advertising the products, and that was investigated and held to full foul of competition law by the CMA. And then finally, just the general activity which can go on and which does go on with supplier issuing threats, warnings, incentives, stopping supply, delaying supply if the party down the supply chain refuses to sell at a particular price. So what's permitted? Well, the setting of maximum resale prices or recommended resale prices are permitted, but it's important that these maximum or recommended resale prices don't morph through other actions of the suppliers into being a fixed or minimum price. And this happened in one CMA investigation where a supplier had set what it called a maximum resale price, but elsewhere in the agreement with the reseller, they prohibited all forms of discounting. So in effect, that was a fixed price. The recommended price, again, if you set a recommended price, it must be a genuine recommendation. The CMA recently investigated Ultra Finishing Limited, which is a bathrooms fitting supplier, and Ultra had provided resellers with online trading guidelines which recommended that online prices should be no lower than 25% less than RRP. And these recommendations were expressly stated in the guidelines to be legally non-binding, fine. But the problem was that CMA will not look at just what's in your contract, but also will look at what's been happening in practice. And what Ultra had been doing was they've been threatening to charge higher wholesale prices if the resellers didn't comply with this recommended price, and they've been ceasing supply as well if resellers didn't toe the line. So the CMA said it's not a recommendation. The action you've taken has made it into a fixed price. Finally, there are some very, very limited circumstances in which fixing prices can be lawful, and that's if there's a benefit to consumers, in a nutshell. Examples are where a supplier launches a new product and wants to get distributors on board to promote that product, then they may fix a price for that purpose. And then another example is if a supplier launches a short-term sales campaign as part of a franchise system. But it's important to note that these exceptions are very limited, very narrow, and there are a number of stringent conditions which need to be fulfilled. The idea is that they are very much exceptions to the general rule. So what should you do if you think your business might be involved in price fixing or price maintenance? Well, the first thing to do is to take advice. That may sound self-serving, but actually the important thing about taking advice in these circumstances is that it might be possible to minimise your exposure or avoid a fine altogether. And that's what you need to sort of be taking advice on, is the sort of approach you should adopt. So, for example, the CMA has a leniency policy for parties who are members of cartels who blow the whistle on the other party. So if you blow the whistle and then cooperate fully with the CMA in its investigation, then you can either benefit from full immunity or a reduction in fines. And this happened in 2012, whereas British Airways was fined £58.5 million for colluding with Virgin to fix fuel surcharges. Virgin received full immunity because it was the party to the arrangement that blew the whistle to the CMA. Another way in which it might be possible to avoid liability is if you're a distributor and your supplier has imposed minimum prices on you, asked you to enter into a minimum price agreement in terms of imposing minimum prices on retailers, and if the court finds that you had no choice but to enter into such an agreement, then it might be possible to avoid or minimise fines that way. So the message is very much from the recent cases that parties that admit their infringements, that cooperate fully with the CMA and which put policies in place to ensure that it doesn't happen again, can very much minimise their exposure. Now I'm going to hand over to Laura, who's going to speak about house accounts.